I could, but I feel like I risk either sounding disingenuous or hypercritical, and I don't want to do either. And the reason I say that is because I've already spoken about how I feel Attorney Reddington has done and what he's accomplished for the defense in just 9 days of the Lindsay Clancy trial. However, I feel like a great way to analyze this would be as if I was sitting in the jury box and I was hearing all of this evidence. We've had the privilege of watching this trial unfold on TV, right? And so the jury they are lay people like myself. And so if the Commonwealth was presenting this to me as a juror, how would I take it? I feel like that's a much more fair way to analyze this. With that said, the prosecution is not done. They haven't rested their case. The defense has not presented their case. There's still more testimony, more evidence. Closing arguments haven't happened yet. There's still a ways to go. However, my question in this video is going to be, if I was a member of that jury, has the Commonwealth convinced me beyond a reasonable doubt in these 9 days? And my short answer is no. I have a lot of reasonable doubt, and I'd like to get into why. So let's begin. On day one, the Commonwealth comes out swinging. Their theory wasn't simply that Lindsay killed her children. They told this jury that this was deliberate, meticulous, and calculated. They portrayed Lindsay as someone who had become controlling, who struggled when motherhood didn't look the way she wanted it to look, who was having difficulty bonding with her children, and who ultimately made a calculated decision to escape motherhood. Well, that matters to me because technically the Commonwealth doesn't have to prove some elaborate psychological motive. But once you give me one, I'm going to hold your evidence up against it. Then they call Patrick Clancy. Patrick is obviously an incredibly important witness for the prosecution. He's the husband and the father of the children. He can establish the household, Lindsay's behavior, the events of January 24th, the errands, and what he saw when he returned home and what happened immediately afterward. But Patrick also gave this jury months of evidence showing that Lindsay was struggling. Severe anxiety, insomnia, medication after medication, psychiatric treatment, suicidal thoughts, hospitalization, intrusive thoughts, and a husband watching his wife deteriorate while she was desperately trying to find something that worked. So almost immediately, I have two competing pictures. The Commonwealth is telling me this woman manipulated everyone around her and calculated an escape from motherhood. But their first witness is showing me a woman who had been actively seeking psychiatric help for months. That's not dispositive. People can suffer from mental illness and still commit intentional crimes. But if you're asking me to believe this was some elaborate manipulation, I'm still waiting for proof of that. In day two, we get what is probably one of the strongest portions of the Commonwealth's case so far. We're on January 24th. We get the text messages, we get PDLACs, we get CVS, we get 3V, we get surveillance. And the theory starts becoming very clear. Lindsay needed Patrick out of that house, and she created a window of time to make that happen. That's powerful circumstantial evidence, but this is also where I started developing questions about exactly how clean this timeline really is. One of the most interesting exchanges for me involved an email Patrick sent to coworkers at 5:24 p.m. That's important. The prosecution described the 5:15 PDLACs text as occurring as Patrick was leaving the house. But when they asked Patrick about that, Patrick himself said, "I don't know if I had left the house yet." Then there's the 5:24 email. The defense asked Patrick whether that email came from his Surface Pro. Patrick said he didn't know, it could have come from his iPhone. Then the Commonwealth comes back on redirect and essentially says, "You were clearly out of the house at 5:24. Patrick's response was not an immediate yes. His response was, "Sorry, what time did you say I was at CVS?" The answer was 5:32. That's when surveillance actually shows him entering CVS. So the prosecutor works backward. CVS is approximately 3 minutes away. If Lindsay sent the PDLACs text at 5:15, Patrick should have been there somewhere around 5:18 or 5:20. But he doesn't enter until 5:32. So the Commonwealth asks whether he could have been sitting in the parking lot sending that email from his phone. Could he? Absolutely. Maybe that's exactly what happened. It's completely plausible, but that's my issue. Could have isn't the same thing as evidence establishing that he did. Patrick couldn't tell us whether the email came from his phone or his computer. He couldn't tell us exactly when he left the house, and the surveillance objectively establishes him inside CVS at 5:32. Everything between those points requires some reconstruction, and again, not accusing Patrick Clancy of anything, I cannot emphasize that enough. I'm evaluating the Commonwealth's timeline, and if your theory depends heavily on Lindsay deliberately creating a very precise window of opportunity, then I need that window established as precisely as possible. Then Patrick gets home. We know what he finds. We know he eventually calls 911. But Patrick testified that it took him several minutes to get the call through because his phone was switching between Wi-Fi and cell service. Now, sitting here outside the jury box, I happen to know something about emergency calls. The FCC requires wireless carriers to transmit 911 calls regardless of whether the caller subscribes to that particular carrier. A phone can attempt to use another available cell network if its normal carrier isn't available, but there still has to be a usable cell network available. So technically, yes, an emergency call can have difficulty connecting under certain connectivity conditions. Fine. Now put me back in the jury box. If I don't know any of that, I'm probably writing down, why did it take several minutes to reach 911? And that becomes more interesting to me later because of what we eventually hear about the Wi-Fi and the cameras. Days 3 and 4 are emotionally devastating. We hear from first responders, we learn what they encountered, we hear about efforts to save these babies. Then the jury physically visits the house and the locations involved in Patrick's errands. And I actually think taking the jury to those locations was a pretty good prosecution move. Now the jury isn't just looking at little dots on a map, they've seen it. They understand the geography, they understand the distances, they understand how quickly someone can move between these places. So I give the Commonwealth that. But I'm also several days into this trial now, and most of what I have learned establishes the horror of what occurred. The defense isn't really disputing that these 3 children died at Lindsay's hands. The fight is criminal responsibility, so I'm still waiting for the Commonwealth to connect all of this physical evidence to what was happening inside Lindsay's mind. On day 5, the Commonwealth introduces Lindsay's own journals. I understand why. There are absolutely entries the prosecution can use to show frustration with motherhood, anxiety surrounding the children, and concerns about bonding. But those journals also contain something extremely important to me: evidence of suffering that predates January 24th. This is Lindsay privately writing about feeling like she is drowning, writing that she wants help, she's deeply depressed, she's having horrible thoughts, writing that she wants to be well. This wasn't something manufactured after 3 children were dead. Those writings already existed. So if the Commonwealth's theory is that Lindsay was essentially manipulating everyone around her or creating this mental health narrative, at some point I need evidence of the manipulation. Because right now, her private writings look like corroboration that she was genuinely struggling. Then we hear this word over and over again regarding her self-inflicted injuries: superficial. Superficial wounds, superficial cuts, and I remember thinking, okay, what exactly are you asking me to infer from that? Because Lindsay didn't merely suffer injuries to her wrists and neck. She also went out a second-story window and sustained catastrophic injuries. So if you aren't suggesting the suicide attempt itself was fake, what exactly are you trying to establish by repeatedly emphasizing that some of those wounds were superficial? That becomes important later when Judge Sullivan, outside the jury's presence, essentially asks the Commonwealth what inference they're trying to make. And the Commonwealth clarifies that they are not saying this wasn't a suicide attempt, they're saying it wasn't a successful one. Okay, but as someone analyzing their presentation, if the judge needs clarification about what your theory is, I'm wondering whether the jury understands it either. Then there's the Apple Watch. Y'all, this piece of digital evidence really bothers me. During Patrick's testimony, the defense showed him Lindsay's Apple Watch sitting in the bedroom drawer. Patrick identified it. And when Reddington referred to it as the watch police had apparently used for the upstairs-downstairs movement information, Patrick agreed. Later testimony established something else. That watch had not been seized during the original search, it was recovered afterward. So does that mean the movement data is inaccurate? Not necessarily, but now I have questions about exactly what that movement data represents. If the Commonwealth is associating movement during this critical period with the Apple Watch, then first I need to know whether we can actually establish that Lindsay was wearing the watch when that movement occurred. And if she was wearing it during the time the children were unalived, what other data exists? Because an Apple Watch is capable of collecting physiological and activity information while it is being worn, but whether any particular data existed here and whether investigators recovered it is something I still need established by the evidence. And that raises an even larger question for me. If digital movement information is helping reconstruct what happened inside this house minute by minute, I would want someone to explain exactly where that information came from. Was it generated by the watch itself? Was it pulled from Lindsay's phone through synced health data? Was it some combination of devices? When was it synced? What timestamps are we relying on? And then I have another question. Do we have evidence establishing that after Lindsay came back upstairs, she took this watch off, placed it in that drawer, then harmed herself and went out the second-story window? Because if we're associating this watch with her movement during the critical period, I would like to understand how the physical location of that watch fits into the sequence of events the Commonwealth is asking me to accept. Hypothetically, right? More importantly, can it actually be established, not just speculated, where this watch was during that critical period at all? And then again, why wasn't the watch seized during the original search? Quick side note here. Massachusetts actually recognizes that deficiencies or omissions in a police investigation can be relevant to reasonable doubt. That's commonly referred to as a Bowden defense. I'm not saying the missed Apple Watch proves the Commonwealth's reconstruction is wrong, but I am questioning the investigative thoroughness here. On day 6, we get to the blood evidence, DNA, exercise bands, toxicology, chain of custody, and Lindsay herself agrees to stipulate to certain evidence so that the Commonwealth doesn't have to bring in witness after witness simply to authenticate facts nobody is seriously contesting. Now let me clarify something because I've seen conflicting information floating around social media about the DNA. From what I researched and what I heard, Lindsay's DNA was indeed found on the blue exercise band. So was Patrick's. So was the DNA of all 3 children. All 5 members of the Clancy family contributed DNA to the end of that blue band. Callan was also identified as a major contributor to DNA from the middle of it. Separately, investigators testified that they could not obtain usable fingerprints from the exercise bands. So what does that DNA evidence tell me? It tells me members of this household had contact with that band at some point. It does not, by itself, tell me when each person's DNA was deposited or under what circumstances. Patrick himself interacted with the bands after finding the children. These were objects inside the family home. So yes, the DNA matters, but mixed family DNA on household property isn't the part of this case that's answering my biggest question. Because once again, I'm still sitting here thinking, but was Lindsay criminally responsible? On day 7, the Commonwealth calls the nanny, and this witness really catches my attention. Because remember the Commonwealth's opening? Controlling, meticulous, difficulty bonding, overwhelmed by children she could no longer control. Then the nanny gets on the stand and describes Lindsay as a wonderful mother. Reddington asks about those extremely detailed instructions Lindsay would leave regarding the children's food and care, and instead of describing those instructions as controlling or overbearing, the nanny describes them as appropriate, attentive parenting. Okay, being a wonderful mother does not mean somebody cannot unalive their children. I'm not saying that. However, the Commonwealth chose a very particular motive story, and some of their own witnesses are making that story harder for me to reconcile. By day 8, I'm beginning to understand another part of the Commonwealth's strategy. Witness after witness interacted with Lindsay. Friends, family members, teachers, people involved in the children's activities. They didn't see obvious psychosis. Okay, that's evidence. I can't discount it. If somebody is walking around floridly psychotic and everyone interacting with that person says everything appeared completely normal, I understand why prosecutors want a jury to hear that, right? But these same witnesses repeatedly describe a loving and attentive mother. Some notice depression, weight loss, anxiety, changes in demeanor. One longtime friend testified that Lindsay told her a medication was causing dark thoughts, and many of these weren't necessarily people Lindsay was confiding her deepest psychiatric symptoms to. So as a juror, my question would become, does somebody appearing normal during a birthday party, school pickup, or ordinary social interaction tell me what their mental state was at the exact moment these children died? Maybe it contributes. Again, I'm not discounting it, but I'm not comfortable making that entire leap yet. Then there's the courtroom stuff I can't completely unsee. And this is separate. I have to put it in its own bubble because not all of it happened in front of the jury. During the autopsy testimony, Lindsay became extremely emotional, so much so that she had to be taken out of the courtroom. That part did happen in front of the jury. The following day, day 9 that is, Reddington told Judge Sullivan that someone from the prosecution had been picked up on a hot mic saying, "Shut her up." The Commonwealth disputes that interpretation and says the comment was, "shut it off," referring to the image being displayed. I listened to the available audio myself. To my ear, it sounded something closer to, "oh my God, shut her up." That's what I hear, but I'm not going to present my interpretation as fact because the audio is unclear. Judge Sullivan later warned everyone in the courtroom that inappropriate comments would not be tolerated. That warning occurred outside the jury's presence. So I can't really put that under what persuaded the jury, but I can put it under my broader assessment of the Commonwealth's courtroom presentation. Same thing with the bows. People noticed that Prosecutor Buckingham was wearing bows after specifically telling jurors in opening that Cora loved wearing bows. I noticed it too. Obviously, the jury wouldn't know the outside conversation surrounding that because they shouldn't be consuming any coverage of this case, but reporting published today found that an attorney who has tried cases against Buckingham remembers her wearing bows and scrunchies before this trial. So unless somebody gives me evidence that those bows are actually connected to Cora, that might simply be part of her personal style. I'm leaving that one alone. Fair is fair. On day 9, we get to witnesses who can actually help the Commonwealth. In my opinion, day 9 gives the prosecution some of its strongest evidence on the issue that actually matters. Is she criminally responsible? We get psychiatrists who actually treated Lindsay. Dr. Goodhart diagnosed Lindsay with major depressive disorder without psychotic features during her McLean hospitalization. Dr. Tuff testified repeatedly that she did not observe psychosis during her treatment of Lindsay. That matters. I'm putting that in the Commonwealth column. And the day before the killings, Lindsay denied suicidal and homicidal thoughts and was able to communicate appropriately during her appointment. Again, point for Commonwealth. But when we really get into Dr. Goodhart's testimony, this is where, as a juror, I start developing some very different questions. Because remember, the Commonwealth wants me to take something important from the fact that Lindsay spent 5 days at McLean Hospital and was not diagnosed with psychosis. Okay, that's significant. But then Reddington starts digging into how that conclusion was actually reached. And this is where I start struggling. McLean did not obtain Lindsay's previous mental health records. They did not have access to records from several of the outside providers who had been treating her. Goodhart testified that Lindsay had not signed a release that would have allowed them to obtain those records. So the people evaluating this woman during a psychiatric hospitalization did not have the complete mental health history of the patient sitting in front of them. Okay. Goodhart also testified that McLean did not use a specific scale to determine the severity of Lindsay's postpartum depression, and there was no blood work done to assess whether her thyroid could be contributing to her symptoms. She also was not aware of psychological testing that had been performed to independently determine whether Lindsay was accurately reporting her psychiatric symptoms. So what are we relying on? To a significant degree. Lindsay and Patrick? Goodhart explained that she had no reason to believe Lindsay wasn't a reliable reporter, and that's where I would start thinking, wait a minute. You're evaluating somebody who has been struggling psychiatrically for months. She's been prescribed multiple psychiatric medications. She's hospitalized because her mental health has deteriorated to the point that suicidal thoughts have become part of the clinical picture. You're considering postpartum depression. You're even considering whether she could have bipolar disorder, but you're relying heavily on the patient herself and her husband to tell you whether she's accurately perceiving what's happening inside her own mind? I'm not a psychiatrist, but that just sounds off. I'm sorry, as a layperson listening to this testimony, that doesn't make sense. Because how is the average patient supposed to know whether what they're experiencing is normal? And if somebody is potentially developing a psychiatric illness that affects insight, judgment, or perception, how capable are they of recognizing their own perception may be changing? That's not me answering the question, that's me asking it. And if you're considering something like bipolar disorder or psychosis, as a juror, I would expect that person's previous records, previous providers, medication history, and a complete clinical history to be pretty damn important, especially when Goodhart also acknowledged that she had never personally treated a patient with postpartum psychosis. Now, that doesn't mean she wasn't qualified to recognize it. Education and clinical training obviously matter, but it becomes another piece of information I have to consider when the Commonwealth is asking me to put weight on her conclusion that she did not observe psychosis. And then we learned something else. Goodhart was considering whether Lindsay could potentially have bipolar disorder, but she testified that she didn't believe she had enough information to make that diagnosis after the limited amount of time she had treated her. That's where my brain goes, okay, you didn't have enough information. That's important, because there's a difference between we evaluated this possibility and definitively ruled it out, and I didn't have information to make that determination. Those are not the same thing. And yet the Commonwealth wants me to take the absence of a psychosis diagnosis during this hospitalization as evidence that psychosis wasn't there. And then during cross, Goodhart had difficulty recalling or locating information Reddington was asking about in those records. Reddington essentially suggested that maybe she needed time to review them, and Judge Sullivan agreed that taking a break was probably a good idea. Now, I'm not criticizing a doctor simply because she needed to look at her notes. However, I am slightly annoyed by that recurring theme in this trial. These medical records are enormous, though, and human beings don't have perfect memories. But this is now another medical witness where, as a juror, I am sitting there watching testimony about Lindsay's psychiatric treatment and thinking, why does this feel like we're discovering gaps in the treatment history while these witnesses are sitting on the stand? Because this isn't the first time I felt this way during the medical testimony. I don't like the pattern. Back to Dr. Tuff for a second. I'm also listening to extensive medication history. Medication gets started, medication gets stopped. Something else gets tried. There are concerns about side effects. There are ongoing complaints about sleep. Her mood remains low, her affect remains flat, she's describing herself as increasingly anxious, and Tuff herself testified that Lindsay's symptoms appeared resistant to treatment to the point that ketamine was eventually something she had considered, although she didn't believe they were at that point yet. Now, once again, I'm not a medical professional. I cannot tell you whether this medication management was appropriate. And I'm not accusing these doctors of malpractice, but sitting in that jury box, the pace of the medication changes and the continued deterioration absolutely catches my attention. And maybe the Commonwealth eventually argues, well, Lindsay wasn't staying on certain medications long enough. Okay, that's something I'm willing to hear, but when I'm also seeing documentation that this woman is experiencing increasingly alarming symptoms, I understand why she's going back to the doctor. And as a human being, if I'm taking something and suddenly I'm having frightening thoughts or I feel dramatically worse, I'm probably calling my doctor too, so I'm struggling with this. The Commonwealth wants me to know that doctors did not identify psychosis, and the defense appears ready to argue, exactly, that was the problem. If the defense eventually presents credible expert evidence that Lindsay had bipolar illness, that it was missed, and that medications potentially contributed to mania or psychosis, then the fact that previous clinicians didn't diagnose psychosis doesn't necessarily prove psychosis wasn't there when these killings happened. Potentially, right? It could become part of the defense's argument that her actual condition was repeatedly missed. And then there's the Wi-Fi. I need a little more explanation on this one. Patrick testified that he had been working from home earlier that day. We know that there were connected cameras inside the house. And now we're hearing testimony involving the Wi-Fi or internet connectivity and why those cameras didn't provide us with footage. Okay, internet service can work in the morning and stop working later. A router can fail. There can be an outage. And yes, if somebody were deliberately planning something, disabling connected cameras is possible too. But I'm not assuming any of those things. I just want to know, when exactly did the internet stop working? Was the Wi-Fi network itself unavailable, or was the router still broadcasting Wi-Fi without internet access? Was anything unplugged? Was there a documented service outage? Like, why? That's my question. When was the last successful connection to those cameras? And how does that fit in with Patrick telling us that when he attempted to call 911, his phone was bouncing between Wi-Fi and cell service? Again, all of that may have a perfectly innocent tech explanation, but I still want the explanation. And last but not least, I need to go all the way back. There's one more thing I don't want to lose in all of the psychiatric testimony and digital evidence. Lindsay's actual physical condition that night. Because Patrick testified that when he found Lindsay outside, he spoke to her. According to Patrick, she told him, "I tried to unalive myself." And when he asked, "Where are the kids?" Patrick testified that Lindsay answered, "They're in the basement." I think that's an important distinction, and it needs to be made. According to his testimony, Lindsay did not tell him outside that house, "I unalived the kids." She said she tried to unalive herself, and she told him where the children were. Standing alone, neither of those statements is actually an admission that she unalived them. Now, days later, Patrick testified that he had another conversation with Lindsay, and that's where we get the much more significant statement. Patrick testified that Lindsay told him she heard a man's voice telling her that if she didn't do it then, she would lose her chance. That statement obviously matters a lot. I'm not negating that. But those are two very separate conversations, occurring at two very different times and under very different circumstances. And I don't think we should collapse them into one confession, because then I have to look at Lindsay's physical condition when Patrick says she made the first statement outside. Again, I'm not saying Patrick is lying, and I'm not saying he didn't hear what he says he heard, but as a juror, I have to weigh his testimony against everything else I've now learned about her physical condition. Her recorded core body temperature when she arrived at the hospital was approximately 82 degrees. I'm left to assume that it was slightly lower when she was first found and then transported. She suffered catastrophic spinal injuries. The medical records reflected a complete injury involving the thoracic spine. There was significant trauma involving her neck and thyroid. The records reference deep lacerations to her arms, including one documented at approximately 3.5 centimeters deep. And the medical records also referenced a significant amount of spinal fluid coming from her nose. That's an extraordinarily medically compromised person. And then I hear from first responders and medical personnel who encountered her afterward. She was nonverbal. At South Shore Hospital, Dr. McDonough testified that Lindsay did not regain consciousness while she was in the emergency room. She was responsive to painful stimuli, but she was not verbally responsive. I'm not saying Patrick didn't hear what he says he heard, but as a juror, I have to ask myself how much weight I give that account when there really isn't another witness who heard Lindsay make those statements. And the medical personnel who encountered her shortly afterward are describing somebody who was profoundly injured and nonverbal. And the later conversation where Patrick says Lindsay told him she heard a man's voice telling her that if she didn't act then, she would lose her chance, well, that raises an entirely different question for me. If the ultimate evidence persuades me that Lindsay was experiencing psychosis during this period, then I also have to evaluate that statement in the context of psychosis. Was she accurately remembering what happened? Was she describing a hallucination? Was she describing a delusional belief she genuinely experienced? Did this happen before or after they told her that her children had passed away? How reliable was her perception of reality at that point? I don't know yet. But I think it's extremely important to separate what Lindsay allegedly said immediately after the fall from what she said days later. Because they didn't happen under the same circumstances, and I don't think they should carry exactly the same weight without asking those questions. I'm being honest about where my head would be as a juror. The defense has been very clear. Their position is not that Lindsay didn't cause the deaths of her children. Their position is that she did. But because of severe mental disease or defect, she was not legally criminally responsible. I understand. But sitting in my imaginary jury box, I still have to ask, what has the Commonwealth itself proven to me beyond a reasonable doubt? And right now, even putting criminal responsibility aside for 1 second, I'm not prepared to treat every part of their reconstruction as established fact. That doesn't mean I believe somebody else killed these children. I don't have evidence of that. I'm not presenting an alternative perpetrator theory. I'm saying that I don't believe beyond a reasonable doubt that the events that they reconstructed were established. Remember, the Commonwealth first has to prove that Lindsay committed these offenses, then criminal responsibility. So where am I on day 9? I have reasonable doubt. I have question in both categories. 1, did the Commonwealth prove that its reconstruction took place the way they say it did, beyond a reasonable doubt? And did they prove that Lindsay Clancy was criminally responsible of the alleged acts, beyond a reasonable doubt? My answer to both would be not at this time, but trial's not over. A lot of evidence still left to present, and we can't make that decision fully, I'm not convinced. Let me know your thoughts. Please keep it respectful. I just did a lot of talking, okay? I did a lot of talking, explaining why I'm feeling the way that I'm feeling. And if you're going to be in the jury box with me and we're going to be in that deliberation room, I'd hope you wouldn't be shouting at me because I'm asking these questions. Call it the Libra in me. But I think a lot of people online are asking similar questions. I think we can at least agree that this is not a clean-cut case. Or if you think it is, please do let me know. I'm interested to hear your thoughts, whether you agree with me or not. We can still disagree respectfully, of course. I'll catch you in the next one.